Have you ever considered that your credit contract might be inherently fraudulent? Allow me a moment to dive into the specifics of why this is not just a possibility, but a serious concern for consumers today. My name is Red Pill Awakened, and my mission is to empower individuals like you with knowledge about your rights. So now that I've introduced myself, we are going to get into your right to rescind. When you purchase a vehicle from a dealership, federal law requires that the dealership inform you of your right to rescind the credit transaction. This right is established under 15 U.S. Code 1635, which outlines TILA, the Truth in Lending Act. Specifically, consumers have the right to cancel certain transactions within 3 business days if they do not receive the required disclosures. If the dealership neglects to inform you about this right, you can still exercise it regardless of how much time has elapsed. Courts have consistently upheld this principle, as seen in Williams v. Countrywide Home Loans, Inc., 504 F3D 1239, 9th Circuit 2007, where the court ruled that the failure to provide the necessary disclosures invalidated the contract. Next, we are going to get into down payment requirements. Additionally, dealerships are not legally permitted to demand a down payment as a condition for financing a vehicle unless explicitly disclosed in the contract. According to 12 CFR 226.18, which is part of the Regulation Z implementing Truth in Lending Act, any terms related to the finance charge must be clearly communicated. Requiring a cash down payment can violate these regulations, as it creates a misleading expectation regarding the total cost of financing. A relevant case is McDonnell v. Hovnanian Enterprises, Inc., 472 F3D 410, 3rd Circuit 2007, where the court found that requiring unnecessary upfront payments constituted an unfair lending practice. And it doesn't stop there. Insurance payment violations is up next. Moreover, if a dealership insists that you pay for insurance up front, this can also infringe upon federal law. Under 15 U.S. Code 1605, the finance charge must encompass all costs associated with the credit, including insurance premiums. If a dealership tries to make you pay for insurance out of pocket, it violates the spirit of this regulation. For example, in Gonzalez v. Scalia, 121 Federal Supplement 3D 1331, Middle District of Florida 2015, the court ruled in favor of the plaintiff when it was demonstrated that the dealership misrepresented the total finance charge by excluding mandatory insurance payments. So start exercising your right to rescind. If you feel your rights have been violated, you have the option to rescind the consumer credit transaction. Begin this process by sending a rescission letter to both the dealership's registered agent and the financial institution involved in the loan. This serves as formal notification of your intent to cancel the transaction, placing both parties on legal notice. You can find guidance on drafting a proper rescission letter through resources provided by the FTC, Federal Trade Commission. Next, it's on to arbitration and potential damages. In cases of arbitration, you may be entitled to seek damages of up to $75,000 if you successfully prove that the dealership has failed to comply with federal regulations. Under the Federal Arbitration Act, 9 U.S.C. 1 and the following, consumers can pursue arbitration as a means to resolve disputes with lenders or dealerships. Businesses typically prefer arbitration to avoid court, especially given the potential for significant financial penalties. A notable case highlighting this is Rogers v. AIG Consumer Finance, Inc., 2004 WL 1348910, 2004, where the court ruled in favor of the consumer in an arbitration setting. Throughout history, several cases have established significant foundations for consumer rights concerning fraudulent credit contracts. Here are some examples. Barker v. American Express, 2001 WL 3454354-3, Central District of California. 2001. The court ruled that inadequate disclosures violated the Truth in Lending Act, allowing the plaintiff to rescind the contract. Another is Baker versus General Motors Acceptance Corporation, 2006 WL 2861088, Northern District of California, 2006. In this case, the court emphasized the importance of transparency in credit transactions and ruled in favor of the consumer due to lack of proper disclosures. And last but not least, Santos versus Citibank, 2012 WL5 67885, Southern District of New York, 2012. This case reaffirmed that consumers could seek restitution for unlawful practices in credit contracts, providing further validation of truth in Lending Act protections. So in summary, if you suspect that your credit contract is fraudulent, you are not powerless. Understanding your rights and the applicable federal statutes can empower you to take action. By knowing how to rescind a credit transaction and the potential legal recourse available, you can better protect yourself against unlawful practices. And once again, this is Red Pill Awakened, and I'm here to wake the people. If you found any value in this video, please like, share, and comment. Until next time, I'm out.